the honor to represent the last 3 known living survivors of the 1921 Tulsa Race Massacre. And we're going to talk a lot today about why this case should move forward, why these survivors should have the opportunity to seek and get justice. But it's really important that everyone understand that if we are truly a nation of laws, this is the case that will prove it. Because for 102 years, 102, Mother Viola Ford Fletcher, 109 years old. Mother Leslie Benefield Randall, 108 years old. Mr. Hughes Van Ellis, we call him Uncle Red, 102 years old. They've been waiting. They've been waiting, just like every other victim and survivor of the massacre, for just an opportunity to have their day in court. And as my team will explain, if this truly is a nation of laws and a state that's based upon the law, these clients, these survivors, will get the opportunity that no one else who suffered the massacre had the privilege to go in court and have a court of law determine what occurred and what does it take to fix or abate the nuisance that was created when 40 blocks was burnt down to the ground, when over 1,500 homes and businesses were destroyed, never to be rebuilt. This destruction occurred because of crimes, and it made property uninhabitable. It destroyed property. And as my colleagues would explain, that fits directly within the Oklahoma Public Nuisance Statute that has been on the books for over 100+ years. What we want to make sure everyone understands that are listening today is that we stand on the shoulders of so many, the thousands that suffered the massacre and the hundreds that have been fighting for justice since that time. And I would be remiss on this day that we filed our Supreme Court appeal right in this building behind me if I didn't mention Professor Charles Ogletree, who the day we filed this petition, this appeal on last Friday, passed away. And as hard, as much pain that we feel right now, standing knowing that Dr. Ogletree is no longer with us physically, we are emboldened to know that he's with us spiritually as we continue this quest, this righteous justice fight to get legal redress. This is not about anything but moving this case forward based upon the law that is actually written. If our Supreme Court upholds their constitutional duty, their oath, looks at the law, there's only one decision that can be made. And that decision is to swiftly, quickly reverse Judge Caroline Wall's unjust and unlawful decision to dismiss, send this case back to the district court, and allow us to move forward with discovery. Now, I have a magnificent team of lawyers and professors, academics, community members. But I want you to hear from our lawyers to talk about, first, why this case needs to be retained by the Oklahoma Supreme Court. Then we're going to tell you why this case by the law should be decided very swiftly. So the first person I want you to hear from is Attorney Jana Knott, who is an absolute appellate rock star, has done appellate work here in Oklahoma for many, many, many years, worked right here in this building for almost a decade. Jana, if you please explain why, based on your experience, this case has to be retained by the Supreme Court and decided in our favor.
Same spell your name, same spell. Jana Knott, Jana Knott. Thank you. And as DeMario mentioned, we filed our appeal on Friday in this case of Judge Wall's decision in the district court. And we asked the court to retain the case. Typically, when an appeal is filed, it gets assigned back to the Oklahoma Court of Civil Appeals for a decision in the first instance. We've asked the court to keep this case and issue a quick and swift decision. Some of the reasons why we believe this case is appropriate for retention: obviously the historical nature of this case, the widespread impact that this case is going to have, not just on the Tulsa Race Massacre victims and descendants, but also because of the way the district court ruled in this case. We believe that there are going to be some effects on the law that she may or may not have thought about or understood, wide-reaching effects on Oklahoma pleading standards in state court. And so we think this case is important from that angle as well. Oklahoma practitioners who practice civil litigation need to be aware that if this case is affirmed, that the notice pleading standards in Oklahoma will be no longer because of the ruling from the district court in this case. As DeMario mentioned, we also filed another pleading asking the court to set this case for oral argument so that our clients, who have waited for so long, will have, their day in court here before the highest court of this state. So we hope that the court will consider our motion for oral argument and set this case here at some point in the fall. So I'm going to turn it over to my colleagues now to kind of help allow them to help explain some of the procedural aspects of this case and what the law is that we're relying on to obtain this reversal. Thank you.
Thank you, Jana. Next, I'm going to ask my longtime co-counsel, Professor Eric Miller, a professor at Loyola Marymount University and someone who's been fighting on behalf of the Greenwood community and survivors and descendants for over 20 years. He's going to talk about this, again, this pleading standard, why it's so important that the court looks at it correctly and makes sure they make the right decision based upon the law. Eric Miller.
Hi, Eric Miller, E-R-I-C-M-I-L-L-E-R. So the big question in this litigation, as it always has been for survivors of the Tulsa Race Massacre, is why does the court hold survivors of the race massacre to a different standard than every other litigant in Oklahoma? In our case, Judge Wall created a whole new law to make it harder for our clients to move forward and achieve justice. In Oklahoma pleading, a lawsuit to get discovery is not supposed to be hard. It's supposed to be easy. But Judge Wall, not once, but twice, created a higher pleading standard requiring us to specify our remedy in a way that no other plaintiff in Oklahoma has been required to do. We are the only plaintiffs in Oklahoma required to state our remedy in advance of engaging in the sort of fact-finding that's usually permitted by Oklahoma law. That's not just unfair, it's literally unprecedented and will impact each and every case filed by plaintiffs in Oklahoma going forward unless the Supreme Court steps in and forces Judge Wall to do the right thing and apply the right standard.
Thank you, Eric. Again, it's very clear. Why should our survivors be treated any different than anybody else in Oklahoma? And to make that point even more clear, my colleague Erica Simonson, who is an outstanding litigator at our law firm based out of New York, Schulte, Roth, and Zabel, she's going to talk about how our case fits exactly the parameters spelled out by this Supreme Court behind me in the Johnson & Johnson case.
Thank you, Martin. Erica Simonson, E-R-I-K-A-S-I-M-O-N-S-O-N. My name is Erica Simonson, and I'm a member of the Survivors Legal Team from Schulte, Roth, and Zabel. Schulte has been involved in this case in representing the survivors since the case's inception, and we remain steadfast in our commitment to justice and to upholding the law as we proceed through this appeal. But the district court's decision was not justice, and it does not comply with the law. We are bringing a public nuisance claim, and during the pendency of this case, the Oklahoma Supreme Court made a decision that clearly outlined what is and what isn't a public nuisance. They provided a roadmap for us and showed us that a public nuisance claim is crimes and it involves injury to property. And there can simply be no doubt that the massacre fits squarely within the bounds that this Supreme Court decided just 2 years ago. However, Judge Caroline Wall, in her decision, either ignored the Supreme Court's decision in Johnson & Johnson or neglected to address it in her decision. And it's critical that the Oklahoma Supreme Court take this case because in less than 2 years, district courts are already misinterpreting this decision. It is absolutely crucial that the Supreme Court take this case, that it decides that the massacre is a public nuisance, that it fits squarely within the bounds of Oklahoma law, and overturns Judge Wall's erroneous decision. Thank you.
Thank you, Erica. So we win based on public nuisance alone, based upon the law. But we had a second claim. And my colleague Randall Adams, also from Schulte Walton Zabel, is going to talk about the unjust enrichment claim. And he's going to explain to you how this shouldn't have even been decided about by Judge Wall, because we had a decision or an agreement with the other side. So, Randall, if you explain that and why this is even more ridiculous than the public nuisance dismissal.
Hi, Randall Adams, Randalladams. I'm from Schulte, Roth, and Zabel. I'll spell that too. SCHULTE ROTHZABEL LLP. So as DeMario mentioned, that we have two claims in this case. One is the public nuisance claim, and the other is the unjust enrichment claim. And I'll tell you what the unjust enrichment claim is. The city of Tulsa has taken the massacre and created it into an object of cultural tourism and made tens of millions of dollars doing that. And it comes back to the question of who does the massacre belong to? And if it belongs to anyone, it belongs to the plaintiffs in this case, the survivors, the last three survivors of the massacre. And so we've taken it's right there in the name, unjust enrichment. It is fundamentally unjust for the city of Tulsa, which perpetrated the massacre, to make money off of the massacre at the expense of people like the plaintiffs in our case, our clients, the last three living survivors. So we brought a pretty straightforward claim that this is a fundamental unjust enrichment by the city of Tulsa, by the defendants, to make money off of the massacre. And more than a year ago at this point, we had an agreement with the defendants that this claim would survive the motion to dismiss so long as we removed certain paragraphs from our last petition. We did this on the record. There was a court reporter there. Everyone saw this happen. And then when we filed our most recent petition, the defendants acted like this agreement didn't exist, moved to dismiss again, and then Judge Wall dismissed the unjust enrichment claim without even mentioning it, dismissed the entire case, mentioned nuisance in the dismissal, but didn't say anything about what the basis would be to dismiss the unjust enrichment claim when there was an agreement on the record that it would survive a motion to dismiss so long as we removed certain paragraphs, which we did. There's no question that we did that. And just to tie this all back together procedurally, the only thing that we're asking the Supreme Court to do at this point is send the case back to the trial court so that we can have discovery and a trial. We're just asking for the chance to prove these claims. We haven't even gotten there yet. We're being dismissed on the basis that we haven't been able to state a claim when Judge Wall found more than a year ago that we actually did. And we're just asking for our day in court, for our plaintiff's last day in court. Thank you.
Well, we have more lawyers that are on this team that are either not here or not going to speak. Before I have our state representative from North Tulsa, from the Greenwood area, and descendant Regina Goodwin come up, I just want to acknowledge this legal team. I do have one of my associates, Kimberly Heppenkemper, that's here today. I also want to acknowledge Spencer Bryan and Brian Turrell. I want to acknowledge Maynard Henry. I want to acknowledge Beatrice Magic Kojo. one of our Lashandra Johnson Peoples and Cordell Cephas. Guys, if I'm missing anybody, please remind me. But we have a very robust team that's been working on this issue tirelessly, because we know as lawyers, we are supposed to be a nation of laws, as I started off this conversation. We also have some community supporters here. We have from ACLU with Tamaya Cox, the executive director. I see my classmate and also Greenwood descendant Jabbar Shumate with the Oklahoma City Urban League, also a former state senator. But if I ask Representative Regina Goodwin, who represents the Greenwood district right down the street here at the Oklahoma Capitol, and is a descendant, so she's speaking both as a representative of the community and as a descendant of someone's family who suffered the massacre.
Thank you, Attorney Solomon. My name is Regina Goodwin. It's R-E-G-I-N-A, Goodwin, G-O-O-D-W-I-N, state representative I do. I'm blessed to represent the Greenwood District. It is unfortunate that we're here today on the steps of the Supreme Court. When you heard over and over again for years why, one, this legal team is prepared. Attorney Solomon Simmons has brought forth a case that cannot be refuted. And so what happens is we have a judge in Caroline Wall who has put up a wall of injustice. What she has done is ignored fine pleading. She has ignored requirements of Oklahoma law. The standard of pleading has been obliterated if this is allowed to withstand. If this is upheld, right, you talk about the bombings, you talk about the destruction that happened on Greenwood. If Judge Caroline Wall's decision is allowed to be upheld, she has blown up a standard long held here in Oklahoma as it relates to just standard pleadings, just so that Miss Viola Ford Fletcher at 109, Miss Leslie Bennyfield Randall at 108, and Mr. Hughes Van Ellis at 102, after 102 years, that they have their day in court. Why is that not allowed? And I think it has been spelled out over and over again. Why should this legal team be held to a different standard that Oklahoma law does not require? So either somebody needs to have a come to Jesus meeting, or somebody needs to understand, as my grandma said a long time ago, all my trials, we have trials just to get into trial.
Come on.
That's what has been the history of many black folks as long as I've been living. And before I was born and long after I'll be gone, for some reason, law is not applied the same to different folks. That's really what's happening here. We got to call it what it is. And I would say, as we talk about Attorney Charles Ogletree, that you knew, that I knew, that many of us knew, God rest his soul, but he had a fight and he had a passion on behalf of not only the survivors, but the descendants.
That's right.
And as a descendant, I stand here for Carly Marie Goodwin, James Henry Goodwin, my great-grandparents, who did not have their day in court. They were rejected outright in 1922. You can't say the statute of limitations had expired. You cannot say that there is not a public nuisance that exists that needs to be abated. So on behalf of my ancestors and for generations unborn, as much as I think many folks in Tulsa want these survivors to die, quite frankly, understand every time they have an unjust decision, justice has died. And we're asking perhaps for a rebirth here at the Supreme Court, that this be placed in the district court where it belongs. And it should have been handled in Tulsa. We don't need to be here today. And it should have been handled 102 years ago. But as God is our witness, we are going to stand on the side of right. There's generational injustice that has to be met with generational right. And understand, we're not going anywhere. I promise you, we're not going anywhere. As long as there is injustice, there will be folks on the side of right that will be trying to get folks in Oklahoma to do the right thing. Oklahoma is not okay. Thank you.
Thank you. And we have other descendants here. My dear sister, Dr. Tiffany Crutcher, of the Terrence Crutcher Foundation, who's also a descendant. Her great-grandmother, Rebecca Brown Crutcher, fled from the massacre. And my wife is here too, who's a descendant, whose grandmother ran for her life down the train tracks towards Sand Springs, along with others, hundreds of others who was fleeing for their lives. And so, as Regina stated, and you see Tiffany here, Dr. Crutcher, this is the survivors of the plaintiffs, but this is also for the descendants and the entire Greenwood community, because that's what this public nuisance is about. We specifically have stated that in a very particular location, in one city, in a neighborhood called Greenwood that had 40 blocks, the property was blighted, made uninhabitable. Isn't that the standard? That's the standard of public nuisance. That's the standard. And no one disputes that. That's undisputed. And that's why we're saying, why are we held to a higher standard? That's a question that we must ask. I want to invite a great supporter and friend of our survivors, of descendants, and of the Greenwood community, a national TV host, national commentator, and just a dear friend to all of us that are fighting for this day in court. Came down all the way from Washington, D.C. to stand with us today, Tiffany Cross.
Thank you, Mario. Hi, everybody. Tiffany Cross. Tiffany, common spelling, Tiffany, Cross like. And thank you guys for being here, for continuing to cover this story fairly and accurately. And I wanted to be here today. I flew down from our nation's capital because this is a very unique time in the country where we are, as a society, questioning the very integrity of the courts. And so right here in Oklahoma, I want everyone to know the eyes of the nation are on Oklahoma and what the Supreme Court will do. I don't think it's fair to say that we're fighting for justice, because justice is an impossibility at this point to give to these survivors and descendants. However, there should be at least an effort to make right what is so clearly wrong. And we cannot claim to care about life and then pray for the death of these 3 survivors who are over 100 years old each. And so we just need 5 justices to do what's right. And I think the important part of having a press here to bear witness is because that has always been the litmus test to hold people accountable, just as it did in on the Edmund Pettus Bridge in Alabama. Had it not been for people bearing witness to pregnant women, children, mothers, and men getting bludgeoned and beaten and murdered, then the civil rights movement would have hit a snag. We would not have seen the same justice. Well, that is what happened here in Tulsa. People were murdered, bludgeoned, they were robbed of their lives and their livelihoods. So if we are to be a nation of laws, we have to ask ourselves the question, are we a nation of laws that only extend to certain kind of people? Why is it that certain people who happen to look like me have to die in spectacular fashion to pierce the narrative of what it is that happens to us? I am asking you, as members of the media, to continue to bear witness to this story and know that there are people all across this country, reporters, assignment editors, I know you guys know this, managing editors, broadcast reporters, print reporters, all across the nation who are watching this very moment. And we're depending on the information that a lot of you carry out here, but I imagine that there will be national reporters to descend on Oklahoma City to watch what happens here today. Because it is not justice to allow over a century of injustice to go uncorrected. And it's a sad sight to see that despite the hard work that DeMario and his team have done for so long, that they are still denied justice. But the sadder part is that we are standing by watching the power structure turn the scene of the crime into an amusement park and continue to benefit from it. These are not opinions. These are things that we ought to be able to stand in the righteousness of truth and, quite honestly, in righteous anger as members of the human race to stand by and watch and see what happens. So I am asking that the justices take note and pay attention and know that the eyes of the nation are not only on Oklahoma City, but the eyes of the nation are on you. And you have a chance to restore faith in the courts, faith in the system and our 3 branches of government that have truly been tested in recent times. And that is all that people are asking for. And so I hope that the justices do what's right, because I think allowing these 3 people and the descendants and the survivors their day in court is a small thing to do that can cast a wide net of influence across this country. So in closing, please remember the eyes of the nation are upon you to do what's right. Thank you.
Thank you, Tiffany. All right, if we prepare to close this press conference. You know, when I went to law school 22 years ago, we take one of the required cases or courses you have to take is con law, constitutional law. And you learn about all these different Supreme Court cases. And one of the most famous cases that all lawyers know about and most people is the Dred Scott case. And in Dred Scott was an enslaved African who was sued for his freedom because he crossed over from a slave state to a free state. And he had won his freedom at the lower levels, and when he got to the Supreme Court, there was a Supreme Court justice by the name of Justice Taney. And Justice Taney decided that Dred Scott, or in general, that black people didn't have any rights that a white man was bound to respect. And that's been a decision that has lived in infamy since 1857. Because Justice Taney did not look at the actual law of the Constitution and apply it fairly to Dred Scott. Now here in 2023, as we stand in front of this Oklahoma Supreme Court building, that same question is there. Do these survivors have the same rights that the Oklahoma courts are bound to respect of anyone else? Because as you've heard, and as our documents that we've provided you, the same documents we provided to the Oklahoma Supreme Court, clearly shows that the law and the facts are on our side. The question is, will our survivors get the due process that everyone else in Oklahoma receives and have their day in court? Thank you. I'll take just a few questions.
Demario, sorry. So it seems like we've been doing the same dance. Like it's disappointing that this is happening. But what would you say to those people who feel like nothing is actually being done and they're anticipating another disappointment because it just seems like loss after loss and people are getting defeated just like many feel?
Well, you know, I'm an old football player. And
I know.
And so you get knocked down, you get run over, but you can't worry about that because you got the next play. And the person in front of you doesn't care that you're thinking about the last play. So we have to continue to move forward with what we have. We have the law and we have the facts. We have passion and we have the history on our side. We can't make the Supreme Court do the right thing. We just giving them all the information, the facts, and the law to give them the opportunity to do the right thing. It's up to them, you know. So that's why you see so many people here today. That's why you see the Human Rights Watch with Jerry Johnson and here today, coming from Washington, D.C., coming from New York to stand in the sun today. You see people like Jason Lowe, another representative here in Oklahoma City, that's here today because people still believe. Look, we know we need a miracle, but we believe in miracles.
Yes.
You know, I'm from North Tulsa, Oklahoma. My mom grew up handicapped. I grew up on SSI. I spent more nights in the ER with my asthma growing up than you can imagine. I'm a miracle. Miracles happen every day, and a miracle's going to happen here.
Any statements on behalf of the survivors to share?
I know Uncle Red has something.
Yeah. You know, they really wanted to be here, they just couldn't. You know. And Tiffany knows it because she was there when I first sat down with Mother Randall over 3.5 years ago to see if she wanted to even go through this fight again. I explained to her, I can't guarantee you anything. But I just want to make sure that, are you up to going through this? And she said, if I'm living, I'm up to fighting for justice. It's the same thing that every survivor I've ever dealt with, and I've represented over 100 of them. If I'm living, I'm going to fight for justice. So they absolutely know what's going on. They know that we're here. They're probably watching right now. And so they've lived a long time. They've seen a lot. 2 world wars, 2 pandemics, Jim Crow, black codes, sharecropping. You're talking about a miracle. They're miracles.
Yes.
We believe.
I know that you guys have hopefully a timeline of this fall, but is there a timeline as to when the Supreme Court has to respond?
Well, our hope is that the Supreme Court would decide immediately to retain this case, right now. And Jana, she's worked so long with the Supreme Court, she knows the timeline, and she knows that's typically where they are. We're asking for them to retain this case now and make a decision as soon as possible.
Because I'm sure the fear is, just like what we saw in Tulsa, they just keep delaying it every single year. I mean, this has gone on too long already.
That's right. That's right. Well, we're asking the Supreme Court to do the right thing, and the right thing is to retain this case immediately. They already have all the facts. Judge Wall clearly violated the law. What she did was unlawful, heightened pleading standard. It doesn't take a lot to look at that and make a decision. All right, guys, one more question.
How has this impacted the families? I know it was such a thriving area, so how does it impact generational wealth and things like that?
Well, I think right now, we have 3 survivors, but we have hundreds of descendant families that we work with. And everyone is just saying, can we have our chance in court? Just give us that. And let us have an opportunity like every other Oklahoman in this country, in this state. Give us our opportunity in court. Thanks, guys.